Yes, Mr. Quinterfall.
My Lords, I appear on behalf of the appellants in this case in an application for permission to appeal, with appeal to follow immediately afterwards, against the order and judgment of Mr. Justice Hayden of the 26th of August. The appeal concerns a decision made at the outset of the hearing the previous day, further to an application made by the appellants to adjourn the hearing in order to allow them to obtain legal representation. The application was made by application notice and was dealt with at the outset of the hearing. My Lords, before I proceed with the application, just to introduce the other members of the court.
Yes, please.
The trust in this matter is represented by my learned friend David Lawson, who's instructed by Hill Dickinson solicitors, and Kiran Bogle is here behind. The guardian is represented by my learned friend Jack Anderson, instructed by Duncan Lewis solicitors, and the intervener is represented by my learned friend Yasmin Jamil, who's instructed by the local authority.
Thank you.
The parents, Mr. and Mrs. A, are present and are seated towards the back of the court. My Lords, the order under appeal relates to the withdrawal of life-sustaining treatment of H, the son of Mr. and Mrs. A. And it's found at B9 of the bundle. B5 of the bundle. The order does not.
I've got the. Is it page 125 in this bundle?
I'm sorry.
Is that right?
Yes, I believe.
Yes.
The order, it is. You'll see, my Lords, that the order does not mention the application for an adjournment, and indeed the original version of the judgment, and the judgment as read out on the 26th, made no mention of the application either.
Right.
A paragraph was inserted subsequently by the learned judge once it became apparent that an appeal under the ground that the adjournment should have been agreed to was likely to be made. And that paragraph of the judgment, which can be found on page 123 of the bundle, it records the reasons that the learned judge gave.
Yes.
Paragraph 43.
Paragraph 43.
Yeah. Did the judge give reasons for refusing the adjournment at the time when it was refused? In other words, orally?
My Lord, yes. And obviously I wasn't representing the parents. I've spoken to counsel who was present, but we have the benefit of a note made by a paralegal for the trust, and that can be found on page 6 of the supplementary bundle. It's a rather short reason, but it doesn't appear as if the judge went into any great detail or heard any particular developed submissions on whether an adjournment should have been agreed to. If we look at the fourth box from the bottom, page 6 of the supplementary bundle, we'll see that the judge's reasons are that the hearing had to go ahead at H's timetable. It was the case must be seen today, and that seems to be the reason. That was given at the time of the hearing. In the judgment, other reasons are given, but it doesn't seem as if those reasons were mentioned to the parties during the hearing, or whether they were able.
But the reasons given by the judge in the hearing do form part of his reasoning for refusing the adjournment, don't they?
Yes, but the reasons about the treating clinicians and the court-appointed expert being in attendance don't seem to have been verbalised during the hearing. They made their way into that paragraph subsequently. My lords, this appeal is pursued. It was originally pursued on 2 grounds, but fortunately agreement was reached on the second ground. So this is a focused appeal. And our argument is that Article 6 of the European Convention on Human Rights, in a circumstance such as this, would have required the judge to have granted a short adjournment in order for the appellants to have obtained legal representation. And
I'm sorry to interrupt you, Mr. Quintavalle, but that raises a question I was going to ask you in any event, and perhaps I can give you notice of it now. Please don't deal with it immediately, deal with it in the course of your substantive submissions. But it did occur to me as I was doing my reading for this hearing that although the ground of appeal is formulated only in terms of Article 6, that I think it's now well established, certainly in Supreme Court decisions, that courts in this country ought not to go to the ECHR as a first port of call. Rather, it's a last port of call after we've been through domestic law. And that was said by the Supreme Court, for example, in a fairness case called Osborne. Lord Reed gave the main judgment in that case, but there are many other authorities to similar effect. And I'm speaking for myself, I've just been wondering, as I was thinking about this case, whether your argument really turns specific on Article 6, or whether it really amounts to a more fundamental submission that there was not a fair hearing here, and that in the circumstances in which the judge found himself, fairness required that he had to adjourn, at least for a short time, so that the parents could obtain legal representation. Is that really what it at heart amounts to?
my lord, that's certainly a fair characterisation of the case. And Article 6, ultimately, as we'll see when we get to it, essentially lays out the same test. And as so often is the case.
Well, it does, but Article 6 may require us to go down many esoteric avenues, such as what is a criminal charge, what is a civil right, what is a determination. But I'm only wondering aloud, and I may be wrong. I've just been asking myself the question, even if we didn't have the Human Rights Act, and we just had a question in a court in this country, where a party finds itself having previously had legal representation, without legal representation for the hearing, and applies for an adjournment, subject to anything anyone else wishes to say. I would have thought we'd ask ourselves the question, well, did fairness require that an adjournment should be granted?
My lord, the heart of the submissions I'm proposed to make today do concern fairness, but the technical questions were, I believe, do also need to be dealt with.
Of course, I understand. And you must make your submissions in the way that you think fit. All right.
I'm grateful. Thank you. And I should say, my lord, that my learned friend, counsel for the Guardian, has very helpfully mentioned too domestic authorities decided it at Court of Appeal level, which dealt with the question of whether an adjournment should have been made or not. In both those cases, it was held that under the circumstances and facts of the case, it was acceptable that no adjournment was made.
Yes.
And I'll have to deal with those
Yes.
cases. But it's on the facts of this particular case, and certainly considering also the criminal dimension, the factual situation is rather different. I submit, and I believe it is necessary to explore, perhaps briefly, the Article 6 implications, because regardless of whether it's a last resort or not, it does nonetheless form part of it.
Yes, and of course, it goes without saying that we've read the skeleton arguments and the other documents that have been placed before us. So you must make your oral submissions in the way that you think fit, but obviously there's no need for repetition of what's been said.
My Lord, I would like to start by looking at the second witness statement of Mr. A, which was made further to an order of this court in order to shed light on the factual situation as to why representation was legal representation wasn't available at the time the hearing started. And Mr. A explains everything that in quite a lot of detail how legal representation was originally obtained.
Do we need to go into this in absolute detail?
No.
I appreciate having the statement so it's all set up, but the bare bones are pretty clear on it, Mr. Quintavalli. Your clients were initially had the benefit of pro bono representation by an experienced barrister who'd appeared in at least one case, actually before me in Ixler. And then they approached Erwin Mitchell to represent them, and Erwin Mitchell applied for legal aid. And during the preliminary stage of the proceedings, therefore, your client were represented, and therefore took part in the instruction of experts and the directions given, case management directions. And it was only at a very late stage that it became apparent that legal aid was not going to be available, at which point the solicitors withdrew, and most unfortunately, Ms. Mulholland was no longer available, having been disinstructed, and your clients were unable to find alternative pro bono representation in the few days before the hearing. That's in essence what the position is.
It is,
and we're in the middle of August, of course.
Yes, if I could just...
it's harder to find representation.
Indeed. If I could just take your lordships to one letter, which explains why Erwin...
I should say, could I just add this, I think it's important, despite the assistance of the trust.
Yes.
Yes, carry on, sorry.
And the Guardian.
And the Guardian.
See, a lot of people involved.
Trust and the Guardian.
So I wanted to take, without going through the correspondence, it's there, but I would like to take the court to one important document, which is the letter which explains why Erwin Mitchell came to be involved, and that's on page 15 of the bundle.
First bundle.
And this is a letter from Miss Mulholland to Mr. and Mrs. A. Of course, Miss Mulholland had been representing clients on public access basis until then. But she explains that she wishes to involve Erwin Mitchell, and she explains in the last paragraph of that letter. She says, these steps to obtain legal aid funding are very important as your case is complex, and it is important for you to have the help of a solicitor as well as a barrister. So this was the judgment of experienced counsel, that this simply wasn't this was a complex case. Far from being a case where someone could act as a litigant in person, it wasn't even a case where having a barrister was sufficient. A solicitor was needed as well. Full representation was required in the opinion of experienced counsel. The only other point, and my lord has highlighted it, but once, and I don't need to go to any specific letters, but there are a great many of them there. But once legal aid, it was apparent that it had been withdrawn, or rather hadn't been granted, because the solicitors were acting on delegated authority up until that point. Mr. A went essentially into overdrive, writing to everyone, trying to involve everyone in finding legal representation. And the frantic desperation is apparent from reading those letters of Mr. A, as he vainly attempted to find representation. And the reason I mention this, and when we come to look at the two domestic cases cited against me, is that this wasn't a case where a litigant, a party, decides on the eve of a trial to change legal team and then hopes to obtain an adjournment on the basis that he's not represented. This is a case where a party, through no fault of his and her own, lost the representation they originally had and did absolutely everything to try and find alternative representation. And the fact is, they found representation. They found a solicitor prepared to take the case on, but who was away. We have no record of how that solicitor came to be contacted, but no doubt there were a great many calls and letters which are not recorded in this correspondence. That solicitor was away on holiday and needed a little bit of time once he came back to instruct counsel and to get on top of the case. The adjournment sought was for 3 weeks. And that was all. And this was in the context of a hearing which lasted, in the end, it was a one-day hearing. So when we look afterwards again at some of the cases dealing with adjournments, where you have courts having at short notice to reschedule very lengthy hearings, which had been set down a very long time in advance, one of our arguments will be that the sort of administrative injustice or difficulties of rescheduling a one-day hearing are not really that very great.
Well, there were a number of expert witnesses who had prepared reports, some of whom, I think not all of them gave oral evidence, some of whom gave oral evidence. So they would have to be available as an adjourned hearing. And of course, this is an extremely urgent case. Because your point is, these problems weren't insuperable.
Well, my lord, it was an urgent case. We say two things to that. Firstly, it doesn't seem as if the appellants were given an opportunity to respond to that particular objection. It's mentioned in the judgment, but it doesn't seem as if it was raised at the hearing as a reason for not going ahead. And secondly, we'd say that in the context of these sort of cases, the treating clinicians, witnesses, are used to being flexible, let's put it that way, and evidence can be given, and often is, by video link from the hospitals themselves.
Well, it's the norm now in the family courts for experts in evidence.
And we also say that to a certain extent, the the assessment that the case was so urgent is in a way prejudging the case, because that obviously isn't it isn't the position of the appellants. Whilst they recognise it's an urgent case, they don't share the opinion of the treating commissioner and of the trust that the case has to be heard immediately because of risk of deterioration to age or of imminent death. That the position they've adopted, they've taken in statements, is they believe they've seen signs of improvement, and that at worst the situation is stable. They don't accept that there's a deterioration which would necessitate the hearing proceeding without any possibility of any adjournment whatsoever. And for the court to hold otherwise before hearing the evidence is we submit in a way to prejudge the very issue under discussion, which is the child deteriorating? Is the child beyond any hope of recovery?
Well, courts always have to form a preliminary view about substantive issues when deciding on A, whether to adjourn, and B, the length of any adjournment.
Yes, well.
And there was clearly strong evidence in favour, which indicated this child was suffering. It was unclear whether he was in pain. It was clear that his condition was deteriorating. And the judge was bound to take those factors into account in deciding, in thinking about an adjournment, and if so, the length of any adjournment.
Well, my lord, in response to that, and fully accepting that the judge has to make those decisions and is obliged to form a view on the papers before him. First of all, if a 3-week adjournment was felt to be too long, it could have been a shorter adjournment.
Yes.
And secondly, this has to be seen within the context of a case, of quite an extraordinary case, probably a unique case in international literature, where a child, or indeed any person, who's been declared to be dead by brain death criteria, properly performed, has essentially returned from the dead.
That's a dramatic way of putting it, Mr. Quintavali.
Well,
What happened was that the five brainstem tests revealed as I understand it, revealed no activity. Hence, the medical declaration was made. And then, subsequently, the child gasped, and it was concluded that in one respect, there is brainstem activity. I'm probably putting it too crudely, but that in essence what the evidence was. And the declaration was promptly rescinded.
But prior to this case, the scientific dogma, we don't need to go to the Royal, to the Academy's document on diagnosing
I don't
death.
find the word dogma help. Scientific, the conventional wisdom amongst doctors.
Well, perhaps we can go to the document, but the conventional wisdom is that this
Yes.
is definitive
Yes,
determination
that's right.
of death. It's
So
not.
but why? How does that impinge upon the judge's decision about the length, whether to adjourn and the length of any adjournment?
Well, how that impinges on the decision is this: that we have the very same doctors who previously insisted, indeed when the original application was made before the court, that H was dead, and therefore ventilation had to be removed because it was futile treatment. And this is Dr. Z. We can look at her witness statements later coming back and saying, no, the child is contrary to...
Again, I don't find the word insist to add to the merits of your argument. And furthermore, it wasn't just those doctors. It was the medical view is unanimous about the child's condition. Now, not just the doctors who formed the view on the brainstem testing.
The medical view before was unanimous as well, that the child was dead. And in the context where the medical view had shown itself to be, in Mr Justice Hayden's term, fallible, this case called for very careful testing of the new medical evidence, some of it given by the same doctors who previously were convinced that the child was in fact dead. And that, in the circumstances, didn't happen. Because the parents weren't given a chance to test the evidence, and this goes to the point of fairness, which we'll get to in due course.
You can make the point, can't you, that all of the legally represented parties were effectively on one side. They were ad idem as to what the outcome should be. Is that not right?
Yes.
The only parties who were opposing that outcome were the appellants.
Yes.
And so if there was to be a meaningful contested hearing, you might say, the judge had to consider carefully whether the evidence should, for that side, should be tested by a legal representative.
Yes.
And as I read his judgment, he hasn't considered that factor, nor has he considered, he says quite broadly, the application was to adjourn for legal representation. But he hasn't considered why the appellants ended up before him without legal representation. Nor has he given any consideration to how long it might take for them to acquire it. Nor has he investigated whether it might be possible to reconvene the hearing in a short time. Those are all points you can make, aren't they?
My Lord, I'm very grateful that those are all points that I do make, and that certainly seems to be the case from the judgment and from the evidence of how the proceedings were conducted. I will take your lordships shortly to the case of Latinchik and Croatia, which talks about the right to adversarial proceedings in the context of examining expert evidence. And we say, and this is a point that needs to be recalled, because often parallels, and we'll be looking at case law related to care proceedings, but these are not care proceedings. These are proceedings which simply wouldn't have come to court unless the parents had objected to what the hospital had proposed to do. Because most of these cases, parents reluctantly agree with the hospital's, with the treating clinician's analysis of the prognosis for of children in these situations. And life-sustaining treatment is withdrawn by consent, and matters simply don't come to court. The only reason they came to court is because the parents said, no, we don't believe the situation is as hopeless as it's presented. And in fact, at least at first step, they were proved to be right. These are not, I mean, as such, these are, and this when it comes to obtaining legal aid, it might seem a little bit of a peculiarity, but these are private law proceedings. The two parties, whilst there is an inquisitorial element to it, because there's an interest of a child at stake, and it's right that there's collaboration between the parties in the court in establishing what those interests are. At their heart, they remain nonetheless adversarial proceedings, and it doesn't remedy absence of legal representation for the court to say, well, that's fine because counsel for the guardian examined that particular witness, even though counsel for the guardian had a diametrically opposed view from the parents, and therefore any lack of representation was remedied by that sort of assistance. We say that isn't the case. So I'll turn very shortly to the case of Latinchik and Croatia. and deal with the right to adversarial proceedings.
Can I ask you, looking at the very first page of the judgment, I've got it here, page 109 of the supplemental bundle, but sorry, that's 109 of the core bundle. If one looks at the judge's list of those who appeared in front of him, do you have anything to say about that?
Well, Lord, I hadn't considered this, but obviously the appellants aren't mentioned there at all.
Well, they mentioned up the page acting as litigants in person, of course.
Well, as I understand the way, what that records, is obviously incorrect on the basis it records that they were parties as respondents, but it doesn't record that they appeared in the hearing.
Well, I think there is a technical question which I examined, but I haven't decided not to pursue. But when someone is represented by a solicitor, and the solicitor withdraws those instructions for whatever reason, in certain circumstances that withdrawal doesn't take effect unless either there's an order from the court or the parties sign a document making themselves litigants in person. Now that isn't something the Mr. and Mrs. A did. They just found themselves in court. They didn't formally ever accept to be, as I understand it, and I haven't seen any documentation suggesting that they were, but they didn't formally take on the role of being a litigant in person. And it's not something I want to say anything more about. It's a technical detail which...
I think that what concerns me is, and I'm not sure whether this is your case or not, but did the judge properly treat your clients as being parties before him? Did he, for instance, invite them to make submissions? He certainly gave evidence, but I don't think from the notes I've seen they were specifically invited to formally make submissions. It's not clear to me that he very clearly recorded what their submissions were. Maybe you're not taking these points, and they are.
My lord, I'm very grateful to take those points, and certainly one of the points I made on the fairness grounds and the skeleton in reply is that the parents weren't able and didn't produce a position statement for the hearing. It's unsurprising, but they didn't, and they certainly didn't make any submissions in law at the hearing. Certainly from the judgment it appears that the father did give oral evidence, but that seemed to be the limit.
Were they invited to question the witnesses?
The only reference I've seen to questioning of witnesses were questions posed to the expert witness, Dr. Briley, prior to the hearing.
If they were parties, they were plainly entitled to examine witnesses. Were they given an opportunity to do that? It's not apparent from the transcript that they were.
No, and my understanding is that they didn't. Perhaps my learned friend, Mr. Lawson, who was...
Would it be helpful just to go through the note? Because, like my lord, it's not clear to me exactly what their role was. I'm looking at the supplemental bundle. Am I in the right place? Oh, I've actually got it separately as a hearing note, 19-page hearing note. Is that the document we're looking at?
Yes.
Okay. So on the first page,
I'm sorry for rising, my lord. There are in fact two hearing notes. So the one you've got separate is a different hearing note. There's the note of Ms. Watson QC who appeared on behalf of the Guardian, but you've got on loose leaf, and you've got a note in the supplementary bundle, which
Okay.
is the note from Ms. Bogle's.
That's the one we're going through. Well, I'm going to have to just find that. So carry on, Mr. Quintaval. I don't want
And the parents' case was characterised as, and Mr. Justice Hayden certainly gave space for Mr. A to explain his religious views, but reading the judgment, one's left with the impression that this is simply the voice of a father hoping for a miracle for religious reasons against the weight of the hospital treating clinicians and science, as it were, on the other hand. And that isn't the parents' case. If one looks at the position taken through their various witness statements, their faith was an important and integral part of their view of the situation. But they genuinely believe that the doctors had got things wrong, and had missed signs of recovery, had missed signs of positivity and of optimism, and were painting an unnecessarily and wrongly bleak medical picture. And it's that part of their case which they weren't able to put, and again, unsurprisingly, they weren't able to put before the court.
Yeah, I think your fundamental submission about fairness is that it may well turn out that they're wrong about that. Sad though that may be for them to accept, but it may turn out that they're wrong about that. But that there is a cart before the horse problem whenever you have a fairness issue. The whole point about a fair hearing is that you don't assume the outcome of the hearing before you've gone through the fair procedure. And your submission is, as I understand it, these litigants in person were simply, with the best will in the world, and without any disrespect to them, but they were not in a position to be able to cross-examine expert witnesses about detailed medical matters, for example. Is that what it amounts to?
It is. Put succinctly, that's precisely it. And when we look at the case of PC and S against the United Kingdom, we'll see the argument raised there that, well, look, it wouldn't have made any difference if people had been represented. And the European Court says, well, that doesn't actually make any difference to how Article 6 operates. If the substantive right exists regardless of whether it would have made any difference or not to the outcome of the proceedings. So my Lord is correct. It may be that the medical evidence is correct, and that the parents' hopes are not founded, but they simply weren't given a chance to examine those questions before the court.
Can I go back to the point, Mr. Quintavalli,
Yes.
about what actually happened? I've now compared the two notes. And according to Miss Watson's note, which is the loose note, the father put some questions to Dr. L. You have these notes, Mr. Quintavalli?
My Lord, I don't have these notes.
Have you seen them?
No, I haven't.
Okay. Well, page 4, for the record, page 4 of the notes shows your client, 1123, putting questions to Dr. L. Mr. H. Yeah. Scrolling down through, I can't see that he puts questions to anybody else, according to this note. And then on page 15, at 1445, parents' evidence not sworn. And there's a long You have that? So
Yes.
unsworn evidence. So how it's described in Miss Watson's note. And then a long passage when your client is speaking. And the judge's comment that I assure you've been clear and eloquent amongst one of the most eloquent litigants person I have had before me, he says. Then the Guardian is sworn. And then page 17, no questions. You see that?
Yes.
And then there's a discussion about CPR. But there's nothing about submissions in this note. So that's what was puzzling me. So I looked at the note in the bundle, your supplemental bundle, and in that it seems to say at page 25 of the supplement, 24 of the supplemental bundle, Judge says submissions question mark, and Miss Watson says I have provided submissions, and there's an exchange. It rather looks to me as though there were no oral submissions. So does that roughly tally with your understanding of what happened? Your clients did not address the court, did not provide a position statement, did not address the court at the outset, asked questions of one witness, gave unsworn evidence through the father, and there were no oral submissions by any party at the conclusion, including your clients. Is that a fair? Have I got it roughly right, Mr. Gwynterwald, about what your client's role was?
My lord, from those two documents, that certainly seems to be the case, and there's nothing from that contradicts the instructions.
And there's nothing in the judgment which suggests conduct.
There's nothing I've seen in the judgment which suggests otherwise.
I think there's a suggestion in the notes in the bundle that Mr. A was invited to ask questions of more than one witness.
My lord, if it assists, I think it's pages 15 and 19 in relation to Dr. Z, and then at page 24 in relation to Dr. Brierley.
Okay.
I think there was one witness where they don't appear. They don't appear to have been invited.
Were they asked questions of Dr. Were they invited to ask questions of Dr. B? Dr. B was the jointly instructed expert. They were.
That's page 24, my lord, that Mr. Anderson just took us to 24 of the supplemental bundle, just 3 lines above the shaded section.
My lords, it's a matter of record that the parents were assisted by a translator. English isn't their first language.
The father speaks reasonably good English. Is the impression I get, but the mother doesn't. Is that right?
My lord,
but English is not their first language.
I hesitate to give evidence, but hasn't been straightforward to get instructions.
But I think your fundamental point would be, even if you had a native speaker of English, how can they reasonably be expected to cross-examine a medical expert?
Yes. And there was also, as is inevitable in these cases, there's a great deal of evidence. We have the full bundle. We don't have the medical evidence bundle.
Well, the medical records in court.
The medical records, I believe, are well over 1,000 pages.
They were part of the evidence.
Yes. If we look at the at some of the letters that the father was sending, one will see that they're screenshots of a telephone. The parents don't have a computer, so all they're looking at documents was through a telephone, and it made it very difficult for those instructing me to compile that list of exhibits. But it's another illustration of the sort of difficulties which they face.
So they were looking at medical records on their phone.
Well, I believe they were given a physical copy of the medical records at some stage, but inevitably in these cases, conducted quickly, the emails are a fundamental part of litigation.
As far as Dr. B is concerned, on the notes in the bundle, he started giving evidence at page 19 of the bundle. And as far as I can see, that evidence ended at page 22 at 1445. There's no indication there that the appellants were invited to examine it, unless I've missed it.
I'm just looking at Miss Watson's.
It would be before Miss Watson, wouldn't it?
Just seeing her notes if she.
I'm sorry. So she called him. Yes. Is that right?
Yes.
Yes, she did. Obviously.
It was a jointly instructed expert from the Guardian.
Yeah. So she called.
My Lords, I'm going to take a cue from my Lord Justice Singh and not dwell on the technical points. They're there in the submissions relating to the criminal limb of Article 6.
Yes. The dispute, I think the only realistic dispute is whether these proceedings, which are certainly not in themselves criminal proceedings, were subject to the requirements of legal representation under Article 6.1. And the case which has very usefully been put before the court by my learned friend Mr. Anderson is, and I apologise in the authorities bundle for the position of some of the authorities which have ended up in the international section, but on page 717 we have the Queen on the application of RJ and the Director of Legal Aid casework, and in that case, inquest proceedings, which involved a party, this case involved a party who seems had accidentally started a serious fire by throwing a cigarette out, and that fire had led to the death of a firefighter. That particular person had gone to the police, turned herself in, and said, "Look, I think I might have been responsible for starting this blaze," and she was prosecuted for arson, and she was acquitted. An inquest was later held because of the death of the firefighter, and she was summoned to appear at the inquest. And her argument was, I need to have legal representation because of Article 6.1 and the criminal limb in particular. And the question before the court was,
is that the case? Has she been charged? Autonomous meaning. And secondly, is an inquest proceeding, a criminal proceeding which necessitates legal representation? And the finding of the court was that in this particular case it wasn't. But importantly, if we look at page 722 of the bundle, the conclusion section, the judge points out that since the person had been acquitted, he didn't think that she qualified as someone being charged. The proceedings had essentially ended, and any further proceedings, he says, would have been very difficult to have been started because of double jeopardy rules. So that she wasn't actually someone at risk if she had needed to attend the proceedings. And while it was, he says, undoubtedly in the interest of justice for her to be legally represented, nonetheless, he also says that she had the possibility, and the coroner would have been obliged to warn her that she had the right not to say anything and not to self-incriminate. We say this situation is very different in this case. There hasn't been any resolution of any proceedings. Mr. and Mrs. A are potentially at risk. And because they're not being called as such to give evidence in these proceedings, it's instead of fact-finding, which needs to be conducted, and which could have very serious outcomes for them. And I hasten to add, as I've recorded in submissions, that the parents are motivated entirely in the best interests of their son. No submissions that are being made for any other purpose. But nonetheless, the reality is there, and we say that the RJ case is actually, and I'm very grateful to my learned friend for having put it before the court, is actually is supportive of the submissions that we're making on the criminal level.
What particular paragraph in Mr Justice Leggett's, as he then was, judgment, what particular words do you rely on?
So in paragraph 25, the claimant is not now being treated as a suspect by the police and is not the subject of any extant criminal investigation by the police or any other body. So this was an important reason for his conclusion. And then 27, where he says that because of how coroner's juries are constituted, that it can't come with a judgment inconsistent with the outcome of other proceedings.
An inquest is an inquiry into the cause of death, which may impinge directly upon the culpability of an individual. How does that compare with the current proceedings, which are completely different?
We say they are completely different. And in the normal course of events, I mean, this is an extraordinary case, not just because of the medical background, but also because of the position that the parents find themselves in. There is a very real risk to them. If life-sustaining treatments withdrawn, and that they face the risk of very serious charges. And that directly follows from the finding of the court. Now, again, it's not suggested that any party should have the right to determine medical treatment, and that's not what a judge would be considering in making a best interest determination. But we say procedurally, in the situation they find themselves in, they need to have, given the very grave consequences, they do need legal representation to ensure that that the conclusions that the hearing reaches are the correct ones.
But you're not suggesting that the representation would be needed in order that they could advance or defend their position against the criminal consequences of a particular finding.
No, that would be for another court. But
Yes.
but the factual findings could very well then feed into that criminal process, and they need to be protected at this stage as well. These are the submissions. The proceedings are open, they're ongoing, they haven't been concluded, they're not concluded as they were in that case, and the parents remain at risk. It's important, given the gravity of what's at stake, that they have the right to ensure that that the judges, that they can challenge the doctors.
The hearing before the judge was involved an entirely forward-looking question. What should happen in the best interests of the child? It's very difficult to see in that context, and there's no determination of what has happened in the past as to why your clients needed representation to protect their first limbs, Article 6(1) rights. The determination of what should happen in the future in the best interest of the child should not in any way be influenced by the consequences in any criminal proceedings for your clients, and no representations made in that regard could possibly be made.
And that's entirely accepted. And there's no suggestion that the judge's determination should in any way be influenced by those possibilities. But the submission is that because that risk exists, the procedural right to have legal representation does exist even in these.
But why is there such a right if their interests in that regard cannot be affected and cannot be taken into account?
Well, it can't be taken into account in determining the treatment that, or the withdrawal of treatment that H is going to have. But it is necessary that they are able to challenge the clinician's findings, the clinician's views, that there isn't any hope for this child, and that the trajectory is a downwards one and not an upwards one.
This is a submission that you're advancing through Article 6, isn't it?
On the criminal limb.
Yes.
Yes.
Which particular part of the criminal limb are you relying on? Is it 6.3c?
The right to legal representation. The difference being this.
The right, well, just help me. I'm looking at
yes.
I'm looking precisely at Article 6. This is, I think, the right to criminal representation we talk about is in 6.3c, is it?
Yes.
Is that right?
Yes.
6.3c reads, minimum rights, to defend himself in person or through legal assistance of his own choosing, etc.
Yes.
So this is about defending himself. That's the right. And then indeed to examine or have examined witnesses against him. So how does this process, this, as my Lord says, forward-looking process about a best interest decision, fit in with the language of defending himself or herself, of course, or examining or having examined witnesses against him or her? How does it fit?
my lords, the case I relied on is page 205 of the authorities bundle, Albert and Lecomte against Belgium, which is a case where two doctors were involved, but the one we're interested in is Dr. Albert, who were facing disciplinary proceedings, which were not criminal proceedings, or did not seem to be on the face of it. There were no, if we look at paragraph 30 in the section saying existence of criminal charges, the disciplinary proceedings, and there weren't any criminal charges at this point in time. Dr. Albert raised the criminal limb of Article 6, and the court had to decide whether in these circumstances the criminal limb applied or not. These were on their face civil disciplinary proceedings, and the argument was that what may come out of these proceedings could lead to criminal charges. And in the end, if we look at the third paragraph of section 30 there, we see, now the Commission had said no, that the criminal limb doesn't apply. The court instead says it does not believe that the two aspects, civil or criminal, are necessarily mutually exclusive. And then it says, nonetheless, it doesn't have to decide this point because they're able to resolve the issue on the civil limb.
Yes.
So, but the court certainly left open the possibility that civil proceedings, which could have implications, even though someone hasn't formally been charged or isn't defending themselves in a criminal context, nonetheless may warrant and necessitate the protection of the criminal limb of Article 6. And the difference is, and I hope it's clear, that the criminal limb necessitates legal representation, whereas the civil limb, in all cases, whereas the civil limb...
Actually, it doesn't. It's in express terms, Article 6.3c says, if he doesn't have sufficient means. So in other words, the state is perfectly entitled, in principle, to impose a means test for even criminal legal aid. But there it is. We do
Yes.
understand your submissions on this, and you've made them very clearly in writing. I am getting concerned, I have to say, about the time
Yes, madam.
for this hearing, and I don't want to curtail your submissions because you have very important points that you need to make. But given that we have understood these in writing, I just wonder how much longer are you going to need in your oral submissions?
Well, I'll move straight to the civil limb submissions.
Well, can you just give me, I won't hold you to it, but how much longer do you need?
I'll try to get through this in 20 minutes.
All right.
So, my lords, if we, paragraph 13 of the permission to do a skeleton argument cites the case of McVicker in the United Kingdom, and that's cited because it lays out very clearly the sort of considerations which the court, the factors which have to be taken into account when deciding whether a case needs legal representation for reasons of fairness. And in paragraph 14, I lay out 5 points which apply, and then in paragraph 15, another 3 points which add to those. I just wanted to just to mention a few more, just to expand very slightly on a couple of those points. We heard from, one of the questions that the court has to look at is if the legal proceedings are complex. We heard from Ms. Mulholland that they were. That was her advice this particular case this was the advice to her clients. The additional complexity is added by the fact that inevitably these cases move at a very fast pace, and that was the point made, first point of paragraph 15. But it's a real problem for people in Mr. or Mrs. A's position, especially when it comes to the filing of any appeals. Because typically judges, even if they decide to stay their judgment after a case like this, will give very little time for an appeal to be lodged. So this adds to the difficulties facing an unrepresented party. And it makes it practically impossible to run a successful appeal without legal representation. This was a problem that they would have faced. And this appeal concentrates precisely on the procedural issue because we have no basis factually to have challenged any aspect of the judgment. We didn't have medical evidence. We didn't have a chance parents didn't have a chance, as we saw, to examine it properly. The 2 points which I look at in a little bit of detail then is the question of the expert evidence and then the question of the crucial consequences. And the cases there mentioned are Latinshic and Croatia, and then the case of PC&S in the United Kingdom for the crucial consequences. Looking first at the expert witnesses, paragraph 50 of the Latinshic case, which is at page 684 of the bundle, paragraph 50 is at 702, it says in the context of expert evidence, the rules on the admissibility thereof must not deprive the party in question of the opportunity of challenging it effectively. And then the question that needs to be asked is, were the parties able to participate at the end of that paragraph properly in the proceedings before the tribunal? I wanted to take your lordships to another part of that judgment which I mentioned before, which was dealing with the right to adversarial proceedings, and that's at page 702 of the bundle of the bundle, and we see that paragraph 49, the concept of a fair hearing also implies the right to adversarial proceedings. And according to which the parties must have the opportunity not only to make known any evidence needed for their claims to succeed, but also to have cognizance of and comment on all evidence adduced or observations filed with a view to influencing the court's decision. And we looked before at the notes of the trial, and our submission is that by being denied legal representation, they didn't have an effective right to adversarial proceedings, and certainly didn't have a right in the context where counsel for one of the other parties was supposed to be remedying that particular deficiency.
Is it your case that parties, that all parties in your client's position should have legal representation? Or are you confining your argument to the particular circumstances that your clients found themselves in the middle of August?
My lord, the argument is confined to the particular circumstances of my clients. I'm not seeking to make a wider submission. But if we look at the care cases, we'll see one of the reasons that my learned friend will deal with them. But we'll see that one of the reasons the judges looking at in fact, I think in the PC&S case, the judge felt that the that the parent in that case was someone competent to conduct the litigation, therefore an adjournment the judge felt wasn't necessary. And there may be cases where it wasn't in that case, the court held there was a breach of Article 6 because of the complexity of the proceedings, but there may be cases where a competent litigant is able properly to conduct one of these cases without. I think it's difficult, but certainly not in this case.
Well, the particular thing about this case is that there are cases where people are acting in person throughout. That isn't this case. In this case, your clients were represented until very shortly before the hearing.
Yes. And their loss of representation, I say this again, it's an important issue. It was through no fault of their own. It wasn't deliberately dismissing their legal team on the eve of a trial, hoping to get an extension that way. This was quite the opposite situation.
But if your clients had been due to be represented at the hearing by leading counsel, and on the morning of the hearing it turns out that leading counsel was ill and couldn't come, it seems to me that on the judge's reasoning, he would still have refused an adjournment, because he'd have said this case has been going on for a month, it has to be dealt with today, I've got to carry on. It seems that he pays no attention, and he doesn't consider in his judgment how it is your clients came to be without representation at the hearing. So that doesn't matter on his analysis. So he seems to have adopted a very, very extreme position, which is that because it's the best interest of the child and it has to be done today, it matters not that your clients have no representation.
That indeed does seem to be the position that Justice Hayden took. I don't want to speculate as to what might have happened in different circumstances. If there had been legal representation, it may well be that the application for the adjournment would have been made robustly, and the objections that the judge might have raised would then have had a chance of being responded to. But that isn't what happened in this case. The other issue is this, though, and this is an important difference in a case where a client may be represented all the way up until the eve of the hearing itself, is that there may be cases, and again, if we look at the two Court of Appeal cases which my learned friend will take us to, the fact that there was legal representation up until the eve of the hearing may make a difference, because all the preparatory work has been done with legal representation. This isn't the case here. It would appear that Ms Mulholland ceased to act towards the end of July, and there's mention of leading counsel, but leading counsel isn't prepared to get involved until the legal aid is sorted out. So there seems to be all the run-up to the hearing, including when reports were coming in and had to be responded to, was dealt with without the benefit of any counsel that we can see. Owen Mitchell was struggling to sort the legal aid issues out and helping as they could, but the preparation for the case was not conducted, we say, in a way which was compliant with Article 6.1 either. So if they had been represented up until the eve of the hearing and the judge decided not to grant the adjournment, perhaps he would have had stronger grounds for refusing the adjournment. But in this situation, where they hadn't been properly represented since all through August, at least, that simply wasn't the case.
Would you accept that the decision to adjourn or not, I mean, this is commonplace every day of the week, up and down the country, in all sorts of civil and family proceedings. Judges are having to decide whether to continue with the hearing or adjourn. Would you accept that that's a broad case management discretionary decision?
It is, and it's a decision which obviously as such would in normal circumstances be difficult to challenge, because the appellate court is not going to be ready to interfere with broad discretionary decision. But in this particular case, and considering also, and here we fall back on Article 6 as a last resort or otherwise, but the judge was forced to consider the implications of failing to adjourn, should have. And in those circumstances, the review that the appellate court has to give to that decision has to be a little bit more attentive, and the discretion has to be.
Well, one of the bases on which an appellate court can properly interfere with such broad case management discretionary decisions is if the trial judge has erred in principle as a matter of approach. For example, failed to take into account relevant considerations that we all know, standard kind of formulae. I think, but tell me if this is right, I've understood your case correctly, that when one looks at paragraph 43 of the judge's judgment, you say he has erred in principle in the approach he took to the adjournment application. By way of example, as my lord has pointed out, he doesn't even mention what the reason was why they were without legal representation at the time of the hearing.
Yes.
That's your submission, as I understand it. Right or wrong, I'm not saying I agree with it, but that in a sense, we have to focus on the detailed facts of this particular decision not to adjourn, don't we? I mean, the case law and Leconte and Albert and so on, it's all very interesting, and I don't mean any disrespect, but isn't it this case we've got to focus on?
Yeah, yes, my lord, and I think it's also a matter of some significance, maybe not a great deal, but some significance that paragraph 43 didn't even appear originally. No reasons were given when judgment was read out on the 26th. It was only inserted late at a later stage. So it seems as if the adjournment application was dealt with in a rather summary fashion, and there was during the hearing itself, and certainly as we said, the parents weren't given an opportunity to respond to any of the concerns that the judge might rightly have had as to why the adjournment should have been refused.
Can I pick up, I'm sorry, we're eating into your 20 minutes. But can I, as it were, follow on from a line that my Lord Justice Phillips has been putting to you with this thought. You do get cases where it is just not possible to adjourn, medical cases. Don't you? Well, you do. Where if you don't make a decision about an operation, then the nature will take its course. Now, the judge was close to saying he thought that was the position here.
Yes.
Do you have any observations about what he if he did think that, what he felt about any other failings on the judge's part?
The difficulty in paragraph 27 and 28 of the skeleton in reply deals with that issue. And if there is an error in approach, it would seem to be that by making the urgency of or putting H's interests as essentially the determining factor in making the decision not to adjourn, that essentially the paramountcy test was being wrongly imported into a decision which isn't related to which isn't covered by Section 1.1. And that we see from the Court of Appeal in Re GB, paragraph 54, which is cited in 27, saying that the decision is a balance. It isn't one where one can say, as it would be in other decisions, that the focus is solely on the child, that the paramountcy principle under Section 1.1 of the Children Act means that it's essentially the trump card. Here instead it is a balance that has to be determined by the judge, and there isn't any evidence in paragraph 43 that balance was conducted at all. And we see from the transcript Miss Watson's evidence that it seems the judge's concern was that H's interest determined everything, determined this question. And if there is an error of law,
it would have been open to the judge to conduct a balancing exercise, not making welfare paramount, but giving such weight as he thought appropriate to the child's welfare in deciding how to adjourn.
Yes, I entirely
agree. And it would have been possible for him to come to a decision that, applying that balance, carrying out that balancing exercise, it would not be right to adjourn.
Yes, I accept.
So he wasn't obliged to adjourn, but he ought to have carried out a balancing exercise. And then, having done so, I'm conscious I'm putting words in your mouth.
I've come to the end.
I'm conscious that having done so, that would have should have affected the way in which he conducted the hearing thereafter.
Yes. And yes.
And that would include, it might be said, one would expect a much greater prominence to be given and to be evident from the transcripts to the involvement of the parents, with things such as clear opportunities to address the court at the outset, clarity about questions, trying to identify what questions they wanted to put and finding ways of putting them, dealing with interpreter issues, closing submissions.
Yes. And if that had happened, this appeal would have been very difficult, I accept. But there isn't evidence of that sort of accommodation, quite apart from whether the balance was conducted or not. And as we've seen, the parents were almost like spectators in the proceedings in which they were central parties.
Well, it seems to me there's some confusion here. The court's job is to consider the best interests of the child, but it does so after having heard from all the parties in an adversarial context. And to say, oh, well, it's best interests, and actually we've got somebody representing the child, so who can make submissions on the child's behalf, so we're okay, seems to me to fundamentally misunderstand the nature of the process, which is that the court hears from all parties, and in the light of those submissions, then decides what's in the best interest.
Yes.
In particular, it might be said, a child's parents.
Yes. If we were dealing with the Mental Capacity Act, which we have been dealing with Lord and I last week, in which similar questions arose, the best interests approach under the Mental Capacity Act, Section 4, expressly requires the court or any decision maker to have regard to the views of others, relevant others, about what is in P's best interests. That's not spelt out in the Children Act, but it must be, for my part, it's fundamental, and parents' views on what is in the interest of the child's welfare must be taken into account.
Speaking for myself, untutored in this area of law, if that's not the subject of previous authority, that seems to me to be clearly right as a matter of principle.
I wholeheartedly agree.
Right, now we've I'm afraid, eaten into your 20 minutes. Is there anything else you'd like to say?
No, my lord, I may, in reply, have something to say about the Court of Appeal domestic authorities, but I'll wait to hear what my lord has to say.
Now, who's going next? Mr. Lawson. I don't want to put any pressure on you at all, just as I haven't wanted to on anyone else, but how long do you think you'll need?
I don't anticipate we'll finish before the short adjournment, but it...
Yeah, but how much time do you need?
Put it that way. 45 minutes?
45 minutes? Well, let's take stock again. Clearly, we're going to go into the afternoon. Mr. Anderson, how long do you think you'll need after that?
My lord, I imagine that some of what I would be saying will be said by Mr. Lawson. I wouldn't have thought I'm likely to need more than half an hour.
Well, let's see how we get on, but we can take stock again at 1 o'clock. But you carry on for now.
My lord, I'm somewhat concerned at slightly shifting sands, that we've ended up with something put on a very different basis from how it started, and the court is therefore hindered by the written, and I fear the oral submissions are prepared with a very different ground of appeal in mind, which is a ground of appeal that Article 6 required an adjournment rather than a misdirection of discretionary decisions.
Mr. Lawson, it occurs to us that given the time we've reached, and we're not going to finish before the short adjournment anyway, would it help if we adjourned now and resumed in an hour's time so that you can make your submissions in one go? And have a chance to think about these things?
Yes, my lord.
And perhaps discuss things with Mr. Anderson to avoid duplication.
Yes, my lord.
Right, in that case, given the time, we will adjourn now until 1:40.
Yes,
All right. And although I'm not going to impose strict guillotines, we will certainly be expecting you to conclude your submissions in 45 minutes, and Mr. Anderson yours in half an hour, which I hope will allow at least a few minutes for reply. All right? 1:40 then.